This is Michael Popok, Legal AF After Dark. Want to know about the D.C. election interference gag order that's up on appeal? What happened at the oral argument? What happened in Thanksgiving and Black Friday briefing by Donald Trump and the Department of Justice to try to bring to the attention of the appellate court the latest attacks on the judge and the law clerk up in New York because of Donald Trump's comments? Then you'll need to tune in to Legal AF, Ben Meiselas, and me on the most recent episode, debated all of these issues. Take a listen.
Donald Trump knows what I just said. His lawyers have told him that. So what is Donald Trump doing to try to stop that from happening? And this is how you know he did it. Because if the facts, well, one, we saw it happen, but this is how you know somebody in general did it. If they're not arguing the facts and they're not arguing the law and they're attacking witnesses, they're attacking the judge, they're attacking the judge's law clerk, that's one of your big red flags that person knows that if they don't derail this through threats and intimidation, that they are going to jail for a very, very long time. And, you know, Glenn Kirshner was on the show with Michael Cohen, and I agree with Glenn Kirshner in the sense that I think that when Trump is convicted, when he is convicted, because I think he absolutely will be convicted, I think Judge Chutkan remands him into custody. I think he does go to prison and a deal's worked out with Secret Service where Donald Trump actually serves time in prison. Judge Chutkan is not going to cut Donald Trump slack, and Trump knows that. So what does he do? Attack Chutkan, attack the witnesses. And when we're talking about the gag order in the Washington, D.C. case imposed by Judge Chutkan, who were some of the people that Donald Trump was threatening? Pence, Meadows, Donald Trump's, the former chairman of the Joint Chiefs of Staff, General Milley. These are all people who worked with or for Donald Trump. I don't want that to be lost, but that I want to frame why we're even talking about gag order, the importance of it, because Trump is threatening them to try to intimidate them and prevent them from testifying, or hope that his minions go after these individuals and something happens. And Trump knows that when he posts, that's what his people do. He's well aware of that. So with that as background, Judge Chutkan entered a gag order, which of course we know. Oral argument, though, was held with the D.C. Circuit Court of Appeals in Popok. You tell us about this 3-judge panel, your observations from the appeal. Right now, the gag order has been temporarily lifted on an administrative basis, but what do we expect to happen next? Any surprises during this oral argument?
Before you leave Ben on the screen for a minute, this is going to be, look at us, black and white. We just tell it in black and white.
There you go.
No smoke or sunshine every week. You and I listened to the 2-hour oral argument on whether Judge Chutkan's decision, based on the facts that she reached as the trier of fact, and a trial judge like Chutkan is given tremendous discretion and tremendous amount of leeway to develop the facts. And she found in a series of filings and evidence that she took at an evidentiary hearing and oral argument that Donald Trump has made inappropriate, violent rhetoric attacks on different constituents of the criminal justice system, of which he is an involuntary participant. Involuntary because he is a defendant facing 4 felony convictions, serious ones, looking at 30 years, 20 years apiece for each of the conspiracies. And with that in mind, the First Amendment rights of somebody like that, and then every court that we're going to talk about today, at least the New York and the DC one, is struggling with the First Amendment rights limited of a criminal defendant and his lawyers within the court system, because they're not unlimited and unfettered. The lawyer for Donald Trump, this appellate lawyer, John Sauer, who when he's not representing Donald Trump, he's a right-wing Federalist Society member who testifies before Congress in favor of MAGA and the weaponization of the federal government by the Biden administration. That John Sauer, his arguments was stitched together with references to things in constitutional law and First Amendment law that don't even apply. None of his case law applied to a criminal defendant or criminal lawyers in a criminal process. He likes to refer to concepts developed about the media, prior restraint, a doctrine that applies to members of the media and publishing companies who cannot be stopped, usually, generally, from publishing information, even if it was obtained through a violation of the law under a concept we call prior restraint, has no place and no role in the analysis of whether Donald Trump can be gagged from using violent rhetoric to intimidate prosecutors, their families, their staff, and witnesses. None. He likes to talk about, in addition to prior restraint, clear and present danger, which is a great title for a lot of movies and books, but has no place in the analysis of whether a First Amendment right of a criminal defendant to attack other participants by name in the system. It's almost like he has constitutional Tourette's. He just spits out concept and phrases from some con law book that he read. He makes himself out to be a constitutional scholar, but not based on what I saw in the 2 hours of oral argument, 80 minutes of which was him dancing on hot coals, trying to answer, but not successfully, questions posed by the three-judge panel. The three-judge panel, Judge Millett, Judge Pillard, and Judge Garcia, is not a great draw for Donald Trump. I'll just say that. It's two Obama appointees and a Biden appointee, but it doesn't matter who appointed them. Their arguments on the Trump side just don't make any sense. And Judge Millett, who I think is going to ultimately be the judge to write the decision, and I think we're going to get that decision very quickly after a last flurry of filings on Thanksgiving Day by the Department of Justice and by Mr. Sauer in a one-page letter the next day. Briefing is now done, unless Donald Trump does something else despicable, and the Department of Justice has to call him out while we wait for the decision by the panel, which is what we call sub judice, or with the panel not yet decided. We'll get that decision, I think, early next week. I think Judge Millett writes it. And what she focused on, and she was the most hard-hitting of the questioners, the examiners for John Sauer, for Donald Trump. She said, what's missing from your argument, Mr. Sauer, is a balancing test. You're telling me that your client is above the law and has a First Amendment right to do and say whatever he pleases. But that's not what the law says. The law says we have to balance his First Amendment rights, whatever they are, and we determine them here, against the fair and proper administration of justice under the Sixth Amendment. And you don't seem to acknowledge that there's even a scale to be used by a court in balancing it. And she also said, and this is where I think we're going to see a little bit of a paring back, I want to get your view, of course, Ben, on this, of Judge Chutkan's order, when they re-gag him, and I believe they will re-gag Donald Trump, I think it'll be a little bit more pared back on some of the language than what is present in Judge Chutkan, because I heard Judge Millett say, we need to be surgical, like with a scalpel, to make sure that we balance properly these two competing interests. We acknowledge that he is the leading candidate for the Republican nomination. However, he's also a criminal defendant in a serious set of felony charges against him in a pending lawsuit. And so they have to be balanced. And John Sauer's like, basically, there's no balance. And you and I hit the nail on the head last week or the week before when we said, and I know I said it in a hot take, they're going to get him quickly wrapped around his own axle, his jurisprudential axle. When they asked John Sauer, I didn't know who the lawyer was going to be at the time. When they asked him, let me understand this. Do you agree with me? Your guy's not above the law. And they actually asked that question. He says, no, my First Amendment. He says, is your guy above the law? No. Okay, we agree on that. Secondly, do you believe that there is an ability for a judge to gag, to stop conduct short of a crime? Because there's already criminal statutes on the books that address witness tampering and some other things. Is your position, I want to get the limits of your position, is your position that the only thing that a federal judge can do is only gag the things that are already crimes on the books? Well, and he couldn't answer it. And she says, you need to answer it. You're here asking me for relief. You need to be able to give me the limits of your argument. And then when he wouldn't do it, she gave it to him. She provided the limits, which is, I do not believe they're going to rule that the only conduct that can be addressed by a gag order by a federal judge is only that which reaches the level of a crime. Because why would you need to have the gag order then and the ability of a judge to control the decorum and the administration of justice? So the writing for me is on the wall. Sure, they gave it to Cecil Van Devender, who's the lawyer for the Department of Justice, and they wanted to test his his position about the limited gag order, and can it be even more limited, and should it be even more limited? But I think they're working from the presumption, Ben, that I could see from the bench and the questions, that a gag order is appropriate in certain circumstances, even balancing the First Amendment rights of somebody. And where do you draw the line? And now they're going to figure out whether Judge Chutkan drew that imaginary line properly or not. I think they're going to carve it just a little bit back. And then there's two choices, and I want to get your view on this. They either do it themselves and blue pencil it. They pull out a pen and they say, well, she was right here, but then Chutkan, we're going to take this language of targeting people. We don't like targeting. We're going to erase it and we're going to call it something else. Are they going to blue pencil it, or are they going to send it back to Judge Chutkan for further evidentiary hearings to come up with another gag order? I want to hear your view. Do you think they re-gag in some fashion? Do you think they go all Chutkan, or do you think they surgically dial it back themselves or send it back to her for some repair?
I think they're going to remand it back to her to conform with the ultimate order, and they're going to provide the language which will look very, very similar to the existing gag order, but it will more precisely use the language from the Gentile case, which is a 1991 Supreme Court case. Then she will immediately utilize, I think, that language would be my prediction. And then, I mean, Donald Trump could then appeal that, but the precedent would already be set, so it would be a frivolous appeal. And then I think the Department of Justice, when they are opposing his appeal, if he tries to appeal the adoption and incorporation of the DC Circuit Court of Appeals language that they'll put in their order, it would be viewed as frivolous and kind of rejected out of hand right away. They're not going to say that there should not be a gag order and that Donald Trump can say whatever it is he wants to say, short of committing another crime. That's, I think you and I both agree, that is not something they're going to allow no gag order to exist. So they'll either allow the existing gag order, or they'll very modify it in a very simple way. During the oral argument, there was a lot of talk about a case, if you were listening to it, and you're not kind of enmeshed in all of the Supreme Court precedent on these issues, you may have heard them saying genteel over and over again. You may be saying, it's a nice word, but why are they saying genteel? Because there was a Supreme Court case in 1991 called Gentile versus the State Bar of Nevada, which tested the rules of professional responsibility in the state of Nevada, which limited the types of statements a criminal defense lawyer and their client could make in a criminal proceeding. And there, although the State Bar of Nevada's rules were ultimately found to run afoul to the constitutional test, the Supreme Court in 1991 found that the test for when a gag order can be imposed and when sanctions can be issued and what type of restraints can exist in a criminal case is whether there would be a substantial likelihood of material prejudice in a case, whether there was a substantial likelihood of material prejudice that would be caused by the conduct or speech of a criminal lawyer or a criminal defendant in a specific case. And so what the Department of Justice was arguing at the oral argument is, look, Judge Chutkan's standard clearly meets the substantial likelihood of material prejudice test because Judge Chutkan, went even narrower than that. She could have said substantial likelihood of material prejudice, but what Judge Chutkan said was significant and immediate risk to become targets. And so the language Chutkan used was slightly different, I think narrower and included within the broader substantial likelihood test. But that's where it really got into the weeds over language, Popok. And that's where I think that here the DC Circuit Court of Appeals is just going to make clear genteel is the standard. And this type of conduct would run afoul to Gentile. And no, Donald Trump can't just say whatever he wants in a criminal proceeding. There's different level of restraints than outside of a situation when someone's charged with felony crimes.
So let me ask you about let me frame the submission that was made on Thanksgiving Day. Justice Never Sleeps, certainly the Department of Justice never sleeps, the one-page response, and get your view of what do you think the impact will be on the appellate panel as they're about to make their decision. So, and this segues a little bit later in our show tonight to what's going on with the gag order, as you said, gaggle, or whatever your comment was at the beginning of the podcast.
Gobble, gaggle,
gaggle for the two gag orders, one in New York and one in DC, who have now, the worlds have collided, understandably so, because if you do bad things in one jurisdiction, it may come back to bite you in the backside in the other jurisdiction. Or as I said on a hot take, if you murder a man in Idaho, it may come back to haunt you when you're up for trial for murder in Ohio. And so you have a submission earlier in the week by the New York Attorney General, Letitia James's office, to the New York Court of Appeals, or at least this intermediary court, the first department over Manhattan issues, in which they submitted the affidavit of Captain Holland being the person responsible for the Department of Public Safety Judicial Threat Assessment Bureau, thank God that exists, to protect judges and staff from being assassinated, attacked, and stalked and things like that in New York. And I assume every court has a version of that. Captain Holland put in an affidavit, a declaration, in which he outlined all of the credible threats that have increased against the principal law clerk for Judge Engoron, who's been mercilessly and improperly attacked by the lawyers for Donald Trump and Donald Trump himself. I mean, hundreds a day, Ben. So many attacks, anti-Semitic, misogynist, threats of bodily harm, threats of assassination, body shaming, you name it, 50, 80 a day email. They cracked or they hacked into her computer, into her cell phone, voicemail messages, and everything else. So much so that it comprises, as of earlier in the week, 275 single-spaced pages of transcripts for all of these merciless attacks on her. On the judge side, they said, we're not going to tell you how the judge was attacked because we don't reveal that. But let's just say the judge had a number of credible attacks on him that I won't reveal in this particular affidavit. The Department of Justice saw that, couldn't ignore it. It went to issues that came up not only during the oral argument, but also in the briefing between the parties, because Donald Trump couldn't help himself from bragging that they got one justice, and we'll talk about it more in the next segment, one justice on an administrative interim basis to agree to a temporary stay order of the gag in New York while the full appellate court made a decision. Same thing that the DC appellate court did. Exactly. Same thing that Chutkan did in staying her own order. It's not amazing to do that. And it doesn't mean you're going to win on the merits. But of course, a justice of the appellate division stayed the gag order in New York. Well, you just opened the door to the gag order in New York issue. And so when this new bombshell affidavit got filed, the Department of Justice said, well, here's some supplemental authority you might want to chew on while you're deciding the issue. Panel, 3-judge panel in District of Columbia. Here's what just got filed about judge threats, to assassinate judges and law clerks in New York by the same guy, the same attorneys. Take a look. And then if there was a stupid response by, and you can talk about it, of course, by John Sauer, a one-page, he must have been in between Thanksgiving, one page, that's it, submission, because he wanted to try to get the last word in. Panel has it, obviously. What do you think the impact is of this, Captain Holland affidavit on the panel in the District of Columbia?
Look, it's powerful. I don't think it really makes a difference for where the panel was going anyway. I think that they recognized the totality of circumstances here, that when Trump does X, Y happens, and they recognize that through the oral argument that there was real conduct that would follow when Donald Trump made these posts. Look, I think adding a mountain of evidence of additional death threats certainly bolsters the view and perspective that there needs to be a gag order in some form imposed. But, ultimately, I don't think it's going to change where the panel was going anyway.
Well, there's an example of what we do every week, twice a week, on a show we call Legal AF, only on the MeidasTouch network. It sits at the intersection of law, politics, and justice. And we duke it out and debate it on issues at that intersection whenever we can. Leaders of Legal AF collectively have 75 years of legal experience as attorneys and practicing trial lawyers, and we bring it to you exclusively on the MeidasTouch network. Help them get to 2 million free subscribers. They're so close as a grassroots independent media network. And if you like hot takes like that one, you're going to love our curated podcast we call Legal AF, Wednesdays, Saturdays, 8 p.m. Eastern Time. Video versions of it on the MeidasTouch YouTube channel and audio versions of it wherever you get your audio podcasts from. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Hey, Meidas Mighty, love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.